What I have for you today is a follow-up on a case that we've discussed before, and it concerns the Danish company Maersk Olie or Gas AS, which is then one of Denmark's largest oil companies. The decision is from 6 September 2023, and if you look at the last sentence, you can see it references the case we discussed before from the Eastern High Court, in which Maersk actually won. However, before the Supreme Court, Maersk has lost. Now, what was the issue here? You have Maersk Olie Oil and Gas, or you have AP Moller Maersk AS as the top holding company of the group in the period from 2006 to 2008. It held Maersk Olie and Gas, which was originally set up to do all Maersk's oil activities in Denmark and the North Sea, but then expanded. It had a oil corporation in Denmark itself called DUC, Danish Underground Consortium, and then it had two subsidiaries, Maersk Oil Algeria and Maersk Oil Qatar, and they each had branches in Algeria and in Qatar where they were exploring for oil. In Algeria, Anadarko was the operator. That was a local oil company. I believe it was government owned, and Sonatrach was one of the parties involved. And in Qatar, the Maersk Oil Qatar branch operated independently as the operator of the Shaheen oil field. All of the facts and the details described here is discussed in my previous videos, and I'll put a link to those videos at the bottom of this one. And then just to briefly describe what we're talking about. So Maersk Oil and Gas, when you come to developing oil fields and until exploring, it was doing the first two steps in the process, which largely involve desktop surveys. You're not drilling for oil yet, but you're reading, you're buying, and you're analyzing the seismic data, etc., etc. And then you will go and you will try and find the oil, right, and get the licenses, etc., etc. But all of that was left to local PEs, and the real question was, should Maersk Olie and Gas AS have charged and allocated these costs to its subsidiaries, and should they have allocated it to their PEs? In other words, should these costs not have been deductible in Denmark, or at least compensated by the PEs from their profits? And the High Court said no, it was not necessary, and look at that video, and the Supreme Court said yes, it should have. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. So let's look at what the Supreme Court said. First, the Supreme Court summarized the facts. This is in Danish, but here's a brief English summary from Google Translate, which just describes the structure that we just talked about. And it talked about the companies and who dealt with whom. You can see that the Algerian state company was Sonatrach, and then there was, both for Algeria and for Qatar, there were parent guarantees given by MOGAS that these subsidiaries will be able to perform their functions, and then they will be able to live up to liabilities. For instance, if there's an oil spill, these were empty companies, they might not have been able to pay for it, but Maersk Olie and Gas definitely had the finances to cover that. And so the court first looks at Algeria and describes how there were no FTEs because there was not operator. Then talks about Qatar and says how Maersk Oil Qatar had the employees because it was the operator in Qatar. And then it concludes, first of all, MOGAS has received no payment from the subsidiaries for the preliminary studies, these first two phases that we looked at, or for the performance guarantees that it gave towards the counterparties of its subsidiaries. And secondly, it received no payment for the support, if you want the back office support that it gave to the subsidiaries in their daily operations. I mean, it charged for that at cost, but it had no markup, and the Danish tax authorities also corrected that. Now, when we look at the Supreme Court's final findings on the preliminary study made and the guarantee fees and whether that should have been charged, the Supreme Court disagreed with the High Court and said yes, it should have been charged, right? And so the Supreme Court says Mogas carried out the necessary preliminary studies for oil exploration. It also played a significant role in concluding the contracts, as it must be assumed that the subsidiaries could only enter into them because Mogas guaranteed their obligations and provided its technical and financial capacity. I mean, these subsidiaries had none of these things when those contracts were entered into, right? It must also be assumed that Mogas had special knowledge and experience regarding horizontal boreholes, which Mogas has continuously made available to its subsidiaries. Now one of the things that Maersk Oil and Gas was quite proud of, and sometimes erroneously has said that they were the ones who discovered horizontal drilling, or at least that's been attributed to them. I don't know whether they made the claim. Is this idea that you don't drill down directly, but you drill sideways and find more oil. And that can lead to issues with country borders and stuff like that, but we'll leave that out of this discussion. But in any case, horizontal drilling was a big thing for Maersk Oil and Gas, and I assume the Danish tax authorities made a big thing here of it, trying to show some special know-how to claim an intangible, etc., etc. The Supreme Court said the feasibility studies and performance guarantees and the associated know-how have economic value for which an independent party would demand ongoing payment in the form of a profit share, a royalty, or the like. It is not important, or maybe not relevant, I depend on how you translate the Danish, that these were preliminary investigations completed long before the income years in question, right? Nor is it relevant that a potential oil recovery presupposed that significant exploration expenses were incurred in the subsidiaries, or that the occurrence of the oil was uncertain. And I think what the taxpayer argued here was, there was a lot of risk involved, and therefore you can't put all this value on these two preliminary studies. But on the other hand, I mean, you wouldn't have gone there and you wouldn't have found anything if you haven't done the preliminary studies, either yourself or paid someone else to do it. And I think that's where the tax authorities come from. And in addition, I mean, the court here talks about royalties or profit share, which means if there was no oil found, or if there was no profit made, there would have been no payment to Maersk Oil and Gas. So there's not that much of a risk in entering into these compensation forms with Maersk Oil and Gas, or MOGAS as it's called here. The tax authorities, the Supreme Court concludes, are therefore allowed to estimate the income relating to these transactions, and then later in the decision, the court describes what this income was that the estimation was, and it says SCAT, the Danish tax authorities, has based its estimate on the profit realized by the group affiliated units in Algeria and Qatar. The National Tax Court, or the High Court effectively, has added that SCAT's increases correspond to a total royalty of 1.7% of the subsidiary's turnover for the period 2006 to 2008. The Supreme Court finds that MOGAS, which has not presented calculations, valuations, or the like, has not proved that these are grounds for overriding the tax authorities' estimates for the income years. In other words, the Supreme Court says this was a fair royalty to impute. And then as far as the writing services are concerned, or the back office services are concerned, the Supreme Court accepts that MOGAS income relating to the time writing at cost is beyond the scope of what would have been achieved if the agreement had been entered into between independent parties. And of course, I mean, these back office services, etc., you will do at least the cost plus, right? The Supreme Court agrees that the tax authorities have rightly estimated taxable income also as regarding to the service, and then the court says in the final findings that AP Møller Maersk and Total Energies, EP Denmark, and Total bought Maersk Oil and Gas after this case was started. So that's why they name them together. And in Denmark, you've got joint taxation, or you've got a fiscal unity if you want. And that's why you've got both companies there, because the one is the real taxpayer who did the transaction, but ultimately the tax is due by the Danish parent with whom it is consolidated, right? And therefore the court says they must acknowledge that the company's joint taxation income for the years 2006 to 2008 must be increased by 500 million for 6, 330 million for 7, and 470 million for 8. So that's the update of the case. As always, court cases remain highly unpredictable. I mean, Maersk wins before the High Court, and then loses before the Supreme Court. I hope you enjoyed this case. I kept to the basics. I don't think there's a whole lot of extremely interesting TP points to cover, other than that this was the outcome of the decision, and have a look at the previous discussion, because it gives a lot more detail of the TP arguments that were presented in that case. See you again next week for another decision. Bye for now.